Okay,
All
all
right. Hi,
right.
folks. This is Kurt Varone,
And Brad Pinsky.
and we're here for another edition of File or Roundup for April 7th of 2025. Brad, take it away.
I feel like it should be April 1st with this first story because I'm not actually sure I believe any of this. I mean, it's so
I, I
unbelievable.
think there's two ways it could go. We'll talk about both of them, but
So the
I,
short facts allegedly, right? Let's say allegedly, this is an arrest. A deputy chief of a Texas-based fire department has now been arrested for hiring a man, allegedly for only $100, but for hiring a man to rape his wife.
no, no, not his wife, a woman.
Rape his
No, not his
girlfriend.
wife. No, 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 no,
Oh,
no.
raping a woman who
Yes.
apparently she wanted. He claimed she wanted to be
No.
raped. I mean,
This is a mess. This is a mess. Let me kind of orient us. There's a question about whether he's a deputy chief because some of the information out there says he's a lieutenant. Other information says he's a deputy chief. But the bottom line is he's an officer in a fire department, and he allegedly hired a man through a hookup app called Sniffies, which
never even heard of it.
here we go,
Yeah.
and paid the man $100 via Zelle, but to rape a woman. Um, and the man apparently did that, and the woman, was not happy with it, and she escaped him, and then he caught up with her and brought her back and whatever. She ended up reporting as a rape. They apparently wanted to do it a second time, and that's when he got caught. Now, she's saying it was not consensual. This was not role play. This was rape. Um, the perpetrator, the man who actually committed the rape, is claiming that the deputy chief put him up to it and said that this was a role play and so on. So you're trying to sort through who's telling the truth, who's not here. My my approach is got to be somebody doesn't just do this once. It's like there's got to be other things going on.
Maybe
And
yeah,
you,
maybe you
you see
arranged
you
this
see what I'm saying?
previously.
So now, having said that, the perpetrator, the man who actually did the rape, is this his first foray in this, or does he have a long history? And might he be falsely accusing the deputy chief of orchestrating that? That's sort of
Right.
one.
One possibility.
Okay. The other possibility is that you've got this deputy chief that's really got something. I don't know whether he's angry with the woman or uh, is getting something out of it or whatever. But again, in either case, if I'm a detective in this, if I'm a prosecutor in this, I'm looking for some indication of something else in their history that would have led them. This is not something that somebody just wakes up in the morning someday and says, "Hey, you know what I'm going to do today?"
No, but what if he's actually telling the truth? He said,
Who,
I had
who,
this
who is?
conversation with my girlfriend, whatever. I
Okay.
right, and she
Yeah.
has a fantasy of this. I'm not judging people, I guess. And so he's like, okay. And
Mhm.
he, right? So the
Yeah.
the office fire department officer reaches out to this guy and says, hey, would you want to take part in fantasy? Now, here's the important part, the interesting part. Let's assume that's true.
That's
The
a
guy
third option I
comes,
hadn't considered.
okay, well, I mean, truth is always a possibility, I guess.
Yeah,
So
right.
the guy, right? But and it's a kink or whatever, but
Yeah.
a weird one. But nonetheless, so then the guy shows up, the hired guy shows up to assault this woman. The woman says no. Maybe he says, listen, I was told she was into this, so no didn't mean no, and screaming didn't mean screaming. That was part of the whole act. I was told. Maybe this guy set up. On the other hand, no always means no, right? I mean,
Yeah.
I don't know. It's going to be
Well,
a
again,
very interesting reasonable doubt issue.
right, and that gets back to my approach. Now, I hadn't thought about that as a possibility. I don't know. Maybe I tend to give women a free pass and say, "Oh no, a woman wouldn't consent to something like that." But
Maybe it was.
assuming that, again, looking back at her, is this something that she has done before, or are there other indications?
Right.
Because how do you tell who's who? How do you know who's telling the truth?
It is a three-way finger pointing. right?
Yeah, it is.
And I don't know. I don't know how you tell, but I agree with you. The investigation, but whose word do you take? I don't know that you could take anybody's word in this because they're all so far-fetched. Ultimately, I think somebody would say, listen, the no, leave me alone, don't touch me, help, rape, allegations, pretty much that means stop, right?
Yeah.
If it was a fantasy, it went too far, stop. If he continued, right? Now, but this was more about the hiring. So,
Yeah.
if there was no assault involved and it's just the hiring, the guy didn't do anything wrong. If there's some discussion of, okay, this is a fantasy, he didn't yet attack the woman, but if he did, Jesus.
What
And it's
what a
crazy.
mess. What
And you
what
know
a
what? If he
mess.
was a plumber, this never would have been in the news.
I don't know. I think it would have, but it certainly wouldn't have been in the fire law news.
Right. Well, that's true. That's true. It just always seems like when it's a firefighter, let's make it
Well,
news.
then, but I don't know. I I keep saying it's like you can't make this stuff up. There's no way. If I gave you that scenario, you'd be like, oh, no way.
No
No,
way.
no
Right.
way.
It's a great criminal law school scenario though.
It,
Like who has what defenses,
it
right? And play
is.
them out.
It
But
is, and it might not even law school, because a lot of the folks use my book in their fire law classes, and the professors, hopefully some of them are regular listeners. This might be an interesting fact pattern
oh
for
yeah,
a law school exam, particularly where you're covering the criminal chapter, the criminal law chapter. Arguably, you might get into the intentional tort chapter, and arguably approach it from the perspective of how many possible torts, in
yeah.
addition to whatever criminal aspects there may be, how many possible civil torts may have been committed here. So just
Very true.
unbelievable. Unbelievable.
Okay, let's go to Chicago. This is a great case which has a simple answer. So before I tell you about everyone about the facts, the answer is you have a policy, and if you have a good policy, this won't be an issue. So what we have is we have 23 or so Chicago firefighters who are alleging that, and I'll give it a basic scenario. Somebody, I think, anonymously calls in and reports to the fire department that somebody unnamed has a firearm somewhere on the premises and maybe in their car in the parking lot. Doesn't name who. So they credit that claim, and they order every firefighter outside to stand by their vehicle. And then, over objections of the firefighters, they search the car, including the trunk area, to search for a firearm. Now, in some states, like Florida, for example, this wouldn't be allowed because there's a specific law that says, you can't penalize somebody from bringing a firearm and leaving it in their car and blah, blah, blah. But so here, the whole question of a Fourth Amendment search is whether there's an expectation of privacy. And in the employment scenario, assuming, and I do assume, that the parking lot they were on was city property, not some off-site parking,
Mhm.
then, and if they had a policy, which we're going to get into, allowing the search under these circumstances and specifying those areas where a firefighter does not have an expectation of privacy, right? Lockers, desks, turnout gear closets, and maybe, right, here you go, in their own vehicles, which are parked in the firehouse lot. There's a big difference I want to talk about with you, and where we should spend some time, versus a locker that the fire department gives you in your own car that you bring in.
Mhm.
That said, so the question here is, does the Fourth Amendment protect it, right? And did they have a valid policy? Is the policy valid at all? Did they have a policy which allows looking at the cars? But then the question I raise is, wait a minute. I'm outside the firehouse. If I brought something to the grounds, does that, my vehicle, does that allow you, just because it's on the grounds, to inspect the vehicle? And here's the thing, if it's at the beginning of the shift, can't you get a search warrant? And I'm not throwing anyone under the bus. I'm not saying it's right or wrong. I'm throwing questions, but first question I have is, do you have an expectation of privacy that can be taken away by a policy in your private vehicle out in the parking lot? And I personally think the answer is yes to some of the vehicle. But then the question is, okay, but were there such circumstances that it was a rush? Couldn't have you said, listen, no, if the gun's in your car, nobody's allowed to go to their cars. We're going to get a search warrant for every one of your cars unless you want to voluntarily open them.
Well, you have a problem there with the search warrant, though. In order to get a search warrant, you need to have a
Probable cause.
crime. You need to have a crime. Okay, there has to have been a crime. And so if someone legally had a firearm, and I think that might be part of the issue here.
It's Chicago. I don't think anyone's allowed to legally have a firearm.
Well, I don't know. Again, I'm in Rhode Island. You're in New
Anywhere,
York.
God knows.
New York is like that. I know.
New York is like
I
that,
have to,
or it is not.
yeah, I have to be very careful if I'm going through New York.
Yes. Or New Jersey or PA or
right, exactly. But pretty much, New York is verboten. But if in order to get a search warrant, there has to be a crime, and then you have to have probable cause to believe a crime has been committed and evidence of that crime exists within the area to be searched. Well, I'm not sure that if you have an unsubstantiated allegation of a firearm in a vehicle,
right.
if you can search 11 vehicles on a search warrant. You can search one vehicle if Firefighter Pinsky or Firefighter Verone's vehicle, or even if you had a pink vehicle or a blue vehicle or a red vehicle, at least you get a little bit. So I'm not sure you're going to be able to get a search warrant. Okay.
Oh, I agree with you. I don't think you will.
Criminal law, and I don't do a lot of Fourth Amendment criminal stuff, but obviously as attorneys we're up on it. You don't need a search warrant to search a vehicle. Okay.
Under exigent circumstances, under certain circumstances.
Well, under normal traffic stops and normal things, because of its mobility, but you do need probable cause. But again, there's got to be probable cause of a crime.
Right.
Not probable cause to believe there's a firearm in it.
Unless it's a crime. Unless that would be a crime.
Unless that would be a crime, obviously, yeah, right.
And it may be in Chicago, probably like New York, you cannot bring firearms to a municipal building. It's a misdemeanor or a felony. Mm-hmm. So I don't know that to be the case in Chicago, but New York and Chicago, as you're saying, are pretty both on the same spectrum. So, so let's just so we don't confuse everybody, the search warrant is needed if there's a expectation of privacy that needs to be overcome. The policy may very well remove that expectation of privacy. There is no question, and I'll take the 3 levels. I kind of always do this. The first level is the fire department gives you a locker. Okay, it's their locker. They're just loaning it to you, so to speak. Even if you get to put a lock on it, as long as you have a policy that says the locker we're allowing you to use on our property, right? You have no expectation of privacy. You can lock it, but we can cut it at any time, that type of thing. Okay, that's easy. Second level is something you do and we do in our must-have policies, which is we talk about you bring a bag in, you bring something into the station and you leave it there. We have the right, it's an option. We're not stating everyone has to have this policy, but if you want to search it, you have to have a policy that says we have the right to search any bags you bring into the firehouse. And if you're going to bring something private and you don't want us to see it, don't bring it. We're telling you. But now we have, okay, you brought a vehicle onto the property outside. Do we have the ability to have a policy that removes your expectation of privacy in that vehicle?
Well, I think you do.
I don't disagree. I just think that's the third question.
And when I lecture on this too, I gotta caveat this by saying just because it's legal doesn't mean I think it's a good idea. Just because I've written policies that allow a vehicle search if you bring it either into the station or onto the city's property, just because I've written policies like that, doesn't mean I think it's a good idea. I think it's kind of offensive.
Yep.
Okay. But at the same time, if you're going to need to search the vehicle, you want to make sure you have a policy that supports that. Otherwise, someone's going to have a reasonable expectation of privacy in what's in their vehicle.
Right. And I don't think anyone can argue exigent circumstances because the car's secure, the person's away from it, they're on shift, they're not leaving anywhere. And by the way, if they left, the crime's kind of over in a sense. Right. But by the way, there also better be a policy that's no firearms at the firehouse, as well as this, and I presume there is.
Yeah. Yeah, well, they list some of I don't think they list the whole policy, but they do list some of the policy. And according to the policy, I mean, I don't know if you look down at the article here. I'm looking at it right now. I'm quoting from the case now. It says the Chicago firearms policy does not prohibit employees from carrying firearms in their personal vehicle. Instead, the Chicago firearm policy only prohibits the following, and then the first bullet point is, while on duty, a city employee who has obtained a license to carry a concealed firearm in compliance with applicable state and federal law may carry a concealed firearm in any area where firearms are not prohibited.
Now, carry versus store in their vehicle, maybe, but again, there's still no policy against it. So it goes back to your first thing. Was it a crime?
Right.
And then and then the question is, okay, is the fire department supposed to be investigating evidence of crimes that are kind of happening on their property? They're not the police.
And right, exactly. But let's get down to maybe like we don't know what happened here. We don't know the basics here. But let's say firefighter A has a violent temper.
Yep.
And we've maybe had to recently discipline them. Maybe there's been some threats, could be social media, could be other places. And
right.
now you superimpose some sort of an anonymous phone call, or maybe it's not. There's two types of anonymous as well. There's anonymous where you don't know who made the call. And then there's anonymous where you've agreed to respect the anonymity of the person who made the call. Okay. But it could be someone who is very close to this person that called and said, my so-and-so, my spouse, my boyfriend, girlfriend, whatever, left for work today.
But they didn't hear. They didn't say whose car it was. That's what's strange to me.
Well, they never found a gun. They never found a gun, which then raises a question: is somebody trying to get somebody else in trouble? And it's kind of like they call it swatting, but is somebody trying to get somebody in trouble or playing a prank, or, not that
firefighters like a bomb threat.
Ever play pranks, but
no, this was just to me, this is just a bomb threat, right? It's no different. Yeah. I mean, it is, but it's not. But
certainly that raised a good point. If we had a bomb threat, could we search those vehicles? I would
if
hope
somebody
so.
said there's a bomb in one of the vehicles, I think you have an exigent circumstance, right? Because a bomb could go off on its own. A pistol, despite what certain people think, isn't going to shoot somebody on its own. So, I'm sorry, New York, firearms don't go off on their own. But no, look, it's such a great question, but I think we should kind of end on what you said a minute ago, which is we're not advising you to have certain policies, but if you're going to want to if you're going to want to search somebody, you need to have it. Now, I do, and you and I have done policies on parking lots, but I go further, right? You can't have a loaded firearm if that's consistent with the law, no bombs, right? No drugs, no alcohol, no people, no dogs, no pets. I mean, I have a long list of things that you're not allowed to store in your car, as well as saying you can't store your car in the parking lot. You can bring it in and it leaves, right? But I have not gone so far as to say, and if we have a reasonable suspicion or have probable cause to believe you violated it, then we're going to go search your car.
Right. That's another thing. And you want to include in the policy, whether it's your locker search policy, your backpack policy, or vehicle policy, that the statement, you have no expectation of privacy in this area, and we reserve the right to go in there for any reason or no reason at any time to search that area.
Yeah.
So, and in the absence of that, there's a factual question about whether or not the person is going to have a reasonable expectation of privacy.
Right. And then you have the other interesting thing is, how do you get the door open? If you have a warrant that says I get to search the car, I'm like, fine, but I'm not opening it for you.
I'm pretty sure they ordered them to stand by with their
They did. They
So
did.
yeah,
They ordered them stand by and open. Anyway, so it's understandable if they had a valid threat. Chicago is a dangerous area. I get the motivation, and we are not saying that they violated the Fourth Amendment. I don't want anyone to think we said that. We have not drawn any conclusion except to say it's a very, very interesting issue presented by a very vague allegation. That's what really bothers me the most about this. I wouldn't have done any of this over somebody who I'm not going to name may have a firearm in their car. How do you even know what shift? How do you even know now? I mean, and I don't know the exact language, but the fact that you can't identify a person to me means you don't know if they're even there.
yeah.
If you knew they were there, then why wouldn't you identify the person? But somebody calling in saying some person I'm not going to tell you about might have a gun in their car. Come on, I
You
wouldn't
know,
have done that.
one of the leading cases, and I forget, I know I used it in my book, and now I can't remember if it went to the U.S. Supreme Court or not, but it was a really interesting case, came from Chicago on locker searches.
Oh,
And it had to, it's so here's another one that, may help give us some clarity on some of this anyway.
yeah, and if it even, I mean, who knows what they'll do, right? But I doubt they're going to drop this. And then the other question is, and we haven't gotten there, and let's not go down this road, but is that a mandatory subject of bargaining? Searching vehicles, et cetera.
I
I
would
would think it would be.
I would think it would be, but a lot of it's going to depend on the collective bargaining law that's applicable, and then the interpretation of that law. Some states give a little bit more latitude than others when it comes to what's bargainable. So
Yeah.
I happen to write my thesis on that in law school. So
Oh, there you
the
go.
scope of collective bargaining for firefighters was my thesis. So.
God, you were geeky even then. Okay, let's go to North Carolina. Um, it's sometimes it's difficult to be a lawyer. Alan Dershowitz said, if something to the extent of you're either 100% in or not on the Constitution, and if you fully embrace the Constitution, you will represent the person whose acts make you sick. Right? You would believe everybody has the right to something, and this is just a guy who personally, what the allegations are, what he said. I don't even know if they're allegations. What he allegedly said, and much of it I'm not going to read, but are just disgusting. Nonetheless, so what we have is we have a North Carolina fire captain. He was terminated because he made a number of social media posts, and he's allowed to proceed in federal court now, even though the court cut down some of the things. But in short, in 2022, he starts kind of a tirade on different topics. First, he goes after the police chief who's dancing at an event and says, "This is the clown in charge of keeping you safe," freaking joke. And he also said, "If I've offended you, I'm sorry that you're a little bitch." And then he goes after trans and gay. He says straight pride. It's natural. It's worked for thousands of years, and you can make babies. And then he keeps going on. He talks about white versus black. He talks about trans issues. So he sued, and the only thing the court left, which shocked the heck out of me, was the First Amendment. Now, we have two First Amendment cases this week. This one, they look at a couple of things. Now, I will say, people want to understand why I'm saying this. This, to me, is how Chip Comstock would approach this case. The
Yeah,
other one is not.
very, very methodical. Yeah.
Yeah, and just starting with what the court said, if the plaintiff can show at least some of the speech at issue implicates matters of public concern, right, then the court has to determine whether the interest in speaking upon these matters outweighs their, expectations, et cetera. But here's the problem I have, and they talk about it. He's a fire chief, right? Isn't he?
Firefighter? Is he a firefighter?
Is it this one or
A
the
captain.
other
He's a
one?
captain.
He's a captain, right? It's the other one I'm thinking is true, but but it's not his job, so he's not speaking as an employee, presumably. So they're questioning whether any of what he says is a matter of public interest, and the court says, yeah, arguably it could be. I don't think it is. I think it's just hate speech or hateful speech, not hate speech, but hateful speech. But the court's going to grant them leeway on some of this stuff to speak about issues which may be, maybe of public interest.
Yeah, well,
And
it
I
doesn't mean
just,
he wins. I think that's the most important thing. He doesn't win on the First Amendment. All they're
no,
saying is you're going to move forward in the process as we start to explore the factual implications of what you said.
right.
Could it cause actual harm or disruption to the mission and functions of the fire department? And if it does, then even if it was a matter of public concern, and even if you said it as a private citizen, you don't have a First Amendment right to say that.
And here we're seeing a growing trend of courts to find that it will create discord in the community and in the employment, because when you are hateful towards, in this case, black, in this case, trans, in this case, gay, and I'll leave out the police chief for a moment, but in these cases, a fire department, right, is there to rescue everybody. And the courts have held that a member of the public could be seen as fearful to call 911 because they don't want this type of person to come. And so does create discord, et cetera, and probably would not be protected, even though it might be in a matter of public concern. Again, free speech is not about whether what you said is tasteful or not, right? It may be very distasteful, my Dershowitz comment, but it's still protected in some cases. But for a first responder to make statements which could, to a member of the public, threaten their safety or make them feel like they're unsafe, that may hit the exception that, yeah, any Joe the plumber making this comment, sure, it's protected, but a firefighter in their own community, maybe not. That would be my 2 cents. I wouldn't protect the speech. I would find it's a firefighter cannot make these types of comments to alienate the community.
Yeah, and I got to agree. I was a little bit surprised that the court allowed it to move on to the next step, but I understand the reasoning. And again, the thing to take away from this is not that this captain is going to win the case in the end. It's just that they're moving on now to a more in-depth analysis of the comments and the impact that those comments can have on the public, and possibly headed to a jury trial on those factual issues.
So now let's see. Oh no. So let's go to, I skipped one. Let's go back to Louisiana.
Sure.
This is confusing, but I think I can summarize it. I watched the news report and everything. Basically, 20 Louisiana, I went to Tulane, I can say Louisiana, firefighters, they're suing that, claiming that the pay scale used violates state law. And if I understand it properly, what they're saying is a new person, after a short amount of time, could make the same salary as a 15-year member, they said, as a 15-year member. And they said state law prohibits that. They also said on the news part of it that the pay scale does not separate and track base pay, raises, and longevity increases, which is going to be an overtime issue because all of those have to be considered, right, in overtime. What is time and a half? Especially longevity, we see all the time get looked over in the time and a half calculation, base pay calculation. So this is interesting, but I guess there must be a state law that requires newer people to get paid less than senior people.
Well, we don't have a copy of the complaint. Certainly, if anybody out there has access to this, I tried to get it and I was not able to get it. The court doesn't have apparently a digital portal to access the complaints, and it wasn't available on Lexis. But I think it raises an interesting question. If you're in a state that does have a requirement for equal pay for equal work, how do you determine whether or not people are equally situated? Okay, and what I mean is, I'm a 20-year veteran, I'm an EMT. All that was required when I was hired was to be an EMT. And now there's a brand new firefighter who's a paramedic, or maybe he's an EMT, but then he went for his paramedic. And now because he's got paramedic and because he's got hazmat certification, which I don't have, he's making more than me. And that's not fair. And that violates the equal pay. And again, I'm not sure, without seeing the complaint, we don't know if that's what the issue is.
Right.
But I think part of it has got to be, are they really equal? And if they are truly equal, if they're both firefighters and none have additional certifications and none have anything else, then, there's a problem there.
Right.
There is a problem. But on the other hand, if, think about the different incentives that fire departments have, some for certainly paramedic, hazmat, uh,
Bilingual. Um,
bilingual, college degree,
yeah.
and other types of things.
Technical rescues, of course, lots of things.
Yeah. So again, I that was my read on this, but again, without actually seeing the complaint, it's kind of hard to speculate. But certainly, if anyone out there has a copy of the complaint, send it to me, send it to Brad, and we'll get it posted on the blog.
Perfect. And lastly, so returning to the First Amendment here, I probably should have done these two in a row, make it a little easier. But now we have the fire chief I was thinking about,
Yeah.
who was terminated, and a court upheld the termination. A really interesting set of facts, and long. So let's see what justice I can do to it. So this was a newly elected board who terminated him. He had claimed, the fire chief had claimed that the fire protection district fired him in 23 as retaliation for the exercise of his First Amendment rights, and the court doesn't agree. And this is where we'll get some discord and stuff. So I'll go through a couple of the facts. Right. Which, let's see if I can do this. And he originally sued with ADA and other things, but the only thing that those were all gone. The only thing that was left at this stage, like we see in the other case, is the First Amendment allegations. So he said he was the only full-time employee originally. There was an election for the fire protection district boards, and so they had all new candidates. There's an individual, Mr. Holt, right, who is acting as fire chief during the election. And this is where it gets a little weird. An individual, Starla Thompson, who was the president, the incumbent president of the board, who lost, filed a complaint alleging election fraud. And against the candidates at that time who were running for the position and by the election workers. So Holt was, the chief, was contacted by an investigator who wanted to, body cam and wanted some statements because he observed that portion or the election. And he releases it. I mean, that's the short of it, right?
He cooperated with the investigation, which what else are you going to do?
Okay. And so the defendant right here contends plaintiff's speech consisted of providing the fire station surveillance video footage to the DA investigator upon being asked to do so and answering some questions about the footage. I can't believe that's not protected. I'm a little shocked.
I think you've got to we got to kind of draw a couple of distinctions here. If what the chief is saying is true, he's saying that he cooperated with an investigation, right, and then as a result of him cooperating with the investigation, he was terminated. Right. Okay. Well, that may not be a First Amendment case, and we got to kind of go back.
We know here it's not. It really isn't.
In the previous case, we didn't really talk about this, but there's the first two prongs of the First Amendment Pickering balancing test. First two prongs is it's got to be a matter of public concern. Okay, an election is a matter of public concern. Here it is. Hands down.
He's got the problem with the first prong, second prong.
No doubt. The second part of it is you have to do it as a private citizen.
And he was there as the fire chief, and the court correctly found that.
And he provided the information. Now, is it wrong that he cooperated with an investigation and was terminated because of that? Absolutely, but it may not be a First Amendment violation. Right. Okay. Might be a whistleblower violation. There might be some other statutory. It might be against public policy. There's a bunch of other things.
I think it's a civil rights violation because what you're trying to do is you're trying to deter somebody from participating in a criminal investigation. And if I was the court, I would have read that into it, whether it was pled or not. I would have read it into it. And federal courts don't like doing that. But I would have said, look, he pled something he didn't maybe with specificity say, but I would have said this is a violation of due process. 14th Amendment. How is an employer going to say to somebody, if you participate in a criminal investigation, we're going to fire you? I don't get it.
But there could be more going on. It could be that he can't connect the two as well. But I would think certainly if I was representing him, I would have alleged a First Amendment violation, but that wouldn't have been my strongest. I would
No.
have alleged some sort of a public policy violation, retaliation, whistleblower violation, and so on. But not, I
And
mean, I
there,
wouldn't have hung my hat on a First Amendment claim.
and I guarantee there has to have been a state. It's not even whistleblower. It's a state immunity for people who participate as witnesses, right? And I'll bet most or all states have them. Can't speak for Louisiana, but most common law states have them that say if you're a witness and you give honest testimony, you cannot be terminated, you can't be retaliated against by any person, any corporation, and certainly not a municipality. So I don't understand what happened here. I'm shocked. And no, nobody should be punishing your employees, right, in any state for participating in good faith in a criminal investigation. But if people are wondering why isn't it First Amendment, let's just say it again. It's because his role as chief was to do this. He wasn't acting as a private citizen. So you're not protected if you're acting in your capacity as, right, a firefighter, et cetera. Maybe he says, well, and they said it was part of his job. I guess the court agreed it was part of his job, but I don't
Well,
know.
it goes back to, in some respects, almost like one of the cases I use when I teach First Amendment is the Foley case out of Randolph, Massachusetts, where the fire department was understaffed. The chief had been asking to increase the staffing. They had a fatal fire. Two people died in the fire, and the chief was at the scene. And the news media asked him, did understaffing have anything to do with the deaths? And he said, as a matter of fact, it did.
Yeah.
And and he was disciplined for that. And again, and his argument was, I spoke truthfully. I answered the question truthfully, therefore the First Amendment should protect me. I was truthful. Yes, I was in my capacity as the fire chief, but if I said I don't have a comment, that would have been a lie.
Yep.
And
Yep.
if I said, staffing didn't play a role, it would have been a lie. So what am I supposed to do? I spoke truthfully, and the court said, absolutely, you spoke truthfully. That's very nice. But
But
the First Amendment doesn't protect you when you speak in your capacity as a fire chief.
And then I go to the second question here and in others. Is there a policy on this? Again, going back to the first case, where's the policy violation, right? You can't just discipline somebody without a violation. What's the policy violation here? No employee shall participate in a criminal investigation against your boss.
As the fire chief, most chiefs, not all chiefs, but most chiefs are at-will employees, and you serve at the pleasure of your, in this case, your board of fire wardens or board of trustees.
But you still can't punish somebody for something that's legally protected. I just can't believe this was legally protected. I feel like we're missing something. I feel like the court's missing something. Maybe it was a horrible pleading and the court says, I'm sticking to the four corners of the pleading. I'm not expanding it. But where are the state law, what we would call pendant claims? You should have brought them along to federal court with you. Where are the state law claims? And maybe I should do 2 seconds of research and look it up, but I'm sure that this state has a protection
This
of
bothers you,
witnesses.
doesn't it? This bothers you that this.
It really does
fired.
bother me.
Yeah. No, I don't blame you. I don't blame you.
Because-
Bothers me that
because-
Chief Foley got disciplined, but
Yeah, but this is the fox watching the hen house. You accused us of election fraud, and we're going to fire you because come on. Anyway, and he didn't even accuse them. He just participated in the investigation. That I do have a problem with this. I do. So anyway, that's it for the week. Great cases and some crazy cases.
That's it. And you're off to FDIC.
I'll be there tomorrow in Indy. I hope everybody comes to my must-have policies class. We have some really timely, interesting stuff we're going to talk about. And if for anyone who wants to go to musthavepolicies.com, you can see Kurt and our policy service that we've been doing very well with.
Absolutely. And we may have to do
maybe Sunday next week. Yeah.
Yeah, we may have to change the time. Brad's got a commitment on Monday, but might be Sunday night, might be Monday night. We'll